Very good evening, ladies and gentlemen. I am pleased to welcome you to the episode 31 of Series 6 of the Basics of Law webinar series, organized by the Webinars and Legal Symposium Committee of the Bar Association of Sri Lanka. At the outset, I wish to take this opportunity to extend my sincere appreciation to the President of the Bar Association of Sri Lanka, Mr. Rajiv Amrasuriya, the Chairman of the Webinars and Legal Symposium Committee, the Co-Chairman, the Secretary of the BASL, the Treasurer of the BASL, as well as the conveners, co-conveners, and members of the Webinars and Legal Symposium Committee for their continued commitment and efforts in organizing this important educational initiative. I also wish to convey my heartfelt gratitude to the Executive Committee of the BASL for their guidance and support. For today's webinar, under the Basics of Law Series 6, Episode 31, we are honored to have us with an eminent and highly distinguished panelist, Dr. Sunil Abeyaratne Attorney-at-Law. Dr. Abeyaratne is a senior attorney-at-law, a commercial arbitrator, and a renowned legal scholar with nearly 4 decades of experience in legal practice, spanning civil, commercial, and criminal jurisdictions. He is widely recognized as a pioneer in ICT and digital law in Sri Lanka and the Asia-Pacific region, and has made significant academic contributions through his seminal works on ICT law. Dr. Abeyaratne holds a PhD in law from the University of Colombo, an LLM in commercial law from Queen Mary University of London, and an MBA in human resource management from the Indira Gandhi National Open University of India. He has served as a visiting lecturer at the Sri Lanka Law College, the University of Colombo and Peradeniya, AFIT, ICBT, and is the chief editor of the Business Lawyer, Law and Management Journal. In addition to his academic and professional accomplishments, Dr. Abeyaratne has held several prestigious leadership and governance roles, including serving as a member of the Law Commission of Sri Lanka, chair of the Data Protection, Communication and Technology Committee of Law Asia, chair of the ICT Lawyers Guild of Sri Lanka, chair of the Institute of Legal and Management Studies, and as a former secretary of the Bar Association of Sri Lanka. It is indeed a privilege to have Dr. Sunil Abeyaratne Attorney-at-Law with us today, and I warmly welcome him to this session. To moderate today's proceedings, we are pleased to have with us Ms.Nirodha Kalansooriya, Attorney-at-Law. Ms. Kalansooriya holds LLM degree from the University of Colombo and the United Kingdom and brings with her over 20 years of experience in legal practice. She is also a visiting lecturer at the Sri Lanka Law College and has extensive exposure to both academic and practical aspects of the law. I warmly welcome Ms. Ms.Nirodha Kalansooriya, Attorney-at-Law, and invite her to moderate today's session. Without any further ado, I now invite her to commence the proceedings.
Thank you, Kitmali. In today's digital world, personal data has become one of the most valuable assets for individuals, organizations, and governments alike. With the rapid growth of technology, online transactions, and digital communication, protecting personal information is no longer optional, and it is a legal, ethical, and professional responsibility. Sir, what is digital law?
First of all, thank you very much, Kitmali, to introduce me and Ms. Nirodha accepting this to moderate this session. Yes, this is a good question you asked. First of all, we must know what is digital law. All are talking about digital law and the digital era. So digital law, we can give various definition. Simply, if we say digital law, the digital law encompasses legal issues related to the use of digital technology, the internet and electronic communications. It includes various areas such as intellectual property, privacy, cybersecurity, electronic commerce, computer crime, online safety or whatever, and then data protection, focusing on how laws apply to this digital domain. So this is the simple definition I can give for digital law.
So why digital law is important in today's context, sir?
Now, the Nirodha, we can see that technology is developing. So last 5 decades, we have seen this tremendous speed that technology is developing. Now, first of all, we must know what is the involvement of information and communication technology to other special to human life. Now, take our key 4 professions. Take medical profession. Today, it has come to the level that surgeons who are working inside operation theaters, or surgical theaters, without using computers, they can't carry their professional duties. They were engineers. To draw high-rise buildings, bridges, they use especially that device like iPad Pro. Even accountants, the same. 20 years back, we saw that how they use calculators and carry their professional duties. So today, it's very difficult to find calculators in the market. So all are using computers. Even as lawyers, we also use computers and accounts package to maintain our law office. Now come to that our profession was noble profession. Now at the moment we can see, I'm very happy that data legal community is stepping into this digital era. So that means all professionals are working with computers and network. It has come to the level that, especially other countries, most of the developed countries and some developing countries, the professionals can't carry their professional duties without using computers and network. Now, take a business world. Most of the leading business establishments in the world, they have already converted their traditional method into digital method. That means that to carry their transactions, they use computers and network. They provide the electronic offer and electronic acceptance. They build electronic contracts. They have expanded their business with other jurisdictions. Under the development of ICT, this is what happened to the business world. They found the new options. So it is very clear the business world also can't survive without using computer and network. Then come to service sector. I will give some examples on the otherwise we are considering time factor. Now take one service sector, transportation. Country like Germany, there are some trains. They say they fly their trains without having engine drivers. Only that's a software operate everything. So even autopilot. So this is a new concept to aircraft. So this is the development of technology as far as the service sector is concerned. Even leisure. I think you would have used that by that time. When you use this some websites, to take example, hotel.com. And the various websites are there. Even for leisure, you can use website and you can make reservation in advance. You will come to know what are the conditions about the particular hotel before you go there. So what the type of food you would get during your holidays. So when you consider the involvement of computers and network our life, that it has come to the level that man can't survive on the earth without using computers and network. Do you think that? Now we discuss about advantages. So like a fairy tale, we can say these are advantages, but in the meantime, there are two sides of the same coin. When you take disadvantages, lots of issues involved in this transaction. There are people, they misuse some electronic communication, electronic contracts. So then when there's a violation of some electronic agreements, when they carry some misuse activities, like a computer crime, so there must be mechanism to deal with these issues. Now, when you carry some transactions using electronic platform, we have to seriously think about the protection of your personal data, personal information. So unlike those days, now it's open, especially when you use internet, the internet called the internet. The internet means it is not Sri Lankan internet or Indian internet or Pakistan internet. It is internet. And it's like internet that you are open, your private life has been exposed to the rest of the world. So then what is the guarantee that the network would give us, or websites can give us when we are using websites and computers? This is another area. Then in the meantime, cybersecurity also come behind us. Now, what is the latest development? Artificial intelligence. Even without giving any human commands, the computer acts as human brain. So when you look at this development, Sometimes when there are issues and problems are there, sometimes you can't find solution only through technology. So then that is why we made a strong legal reforms to deal with certain issues as far as this development of ICT sector is concerned. So that is why we have to seriously think about this digital law. So digital law is crucial in today's context due to the pervasive nature of digital technology, as I explained you earlier, business, communication, and daily life. It helps to address legal issues arising from digital transactions, protects consumer rights, especially consumer protection is another area, and safeguards data privacy and ensures compliance with laws governing cyberspace. So that is why we need this digital law, Nirodha.
Thank you, sir. Sir, now, is it mandatory to learn digital law in legal education?
I think you have to speak to your own heart and find out this answer. Under the developer, as I explained you earlier, now you have realized it is mandatory in the sense that one can't say that you must learn. Considering the speed of the development of ICT sector, that you will realize whether if we don't know this area, whether we could survive, especially in legal profession in future. So to your question, the answer is, while not always mandatory, learning digital law is increasingly relevant in legal education. As technology evolves, understanding its implications becomes essential for future legal professionals to effectively navigate the legal landscape. Remember, this is a new medium now. It's electromagnetic medium. It's a magic medium. Earlier, we used with papers, pencils. Now, today that we are using the electromagnetic field medium to carry transactions. It is intangible. Its nature and behavior of this medium is completely different to traditional medium. So then it's high time to transform legal systems also from the traditional into digital. So in this journey, there may be some difficulties. Of course, we learn lots of subjects during our law schools days, the law college or faculty. But it's high time to reshape all these laws we learned during our students' days at this law school. One thing you have to find. You name any subject other than Roman law. Then tell me what is the subject. You can go ahead without computers or network. Today, the development of ICT sector involves land law, including partition law, maybe personal law, commercial law, criminal law, all these areas. Because when you say this ICT laws or digital law, so this is one step ahead of our legal mechanism, legal system. So now I think you have to find out the correct answer, whether it's mandatory or not in future.
Thank you, sir. What are the subjects, sir, discussed? What are the fields covered under the digital law?
As far as digital law is concerned, it covers various fields, including especially cyber law. Cyber law means legal issues concerning the internet and online activities. And data protection law, regulations regarding the collection and use of personal information. Now today, all these countries, they're particularly concerned about your personal data, especially in European Union. Time to time, they introduce various new provisions and find mechanism and get the best results to protect personal data of people. Then the other area is intellectual property law. The rights related to creation of the mind in digital format. As far as intellectual property laws are concerned, because copyright, patent right, and those days we discussed about trademark. Today that we are discussing about domain names and unfair trade practice in cyberspace, and the new rights called topography, semiconductor chip rights. So this is another area. Then e-commerce law, legal principles governing online business transactions, including consumer protection. Then, in addition to that, cyber security also law, cybersecurity law here, right? Cybersecurity law also play. Their role play is also very important for the development of ICT sector. The legal standards and regulations to protect against cyber threats are there. So these are the basically these are the main subjects we can think about and we can learn under this digital law.
Thank you, sir. So it is a trend today to carry out businesses and professional matters using computers and network. Sir, what is e-commerce? Can you explain?
During Ferdinand Magellan and Vasco da Gama, also the traders, merchants, they carried their transactions. Those days, during their period also, they entered into various written agreements, contracts. Those days, they used not even paper, they used papyrus. When they carried the commercial activities using papyrus, we didn't call that the commerce as papyrus commerce. It's commerce. Even when you use paper-based medium, it's also commerce. Now, today, what happened? The medium of communication has been changed now. It's electromagnetic medium. Now, today we carry sometimes same business activities through this medium. When we carry this electronic medium, we call that commerce as e-commerce. So this is the difference. Basically, this is the difference. Now, we must realize that I think all know what is law of contracts. Law of contract. There are various principles comes under law of contracts. Offer a theory, then counteroffer, then exemption clauses, the misrepresentation, the mistakes, unilateral or bilateral or multilateral mistakes. So then innocent misrepresentation, the fraudulent misrepresentation, illegal contract, those are the principles we learned under law of contract. Because we learned these principles for law of contracts under our traditional transactions. As I explained to you earlier, those days we use paper pencil. Now it's electronic medium. Now we must know whether we are in a position to apply same principle for these transactions. Whether we can apply same principles we learned under law of contracts to apply electronic contracts, electronic communication, electronic transaction as it is. So if we can apply, then there won't be an issue. But considering the nature and behavior, then of course you have to identify the pros and cons of application of principles we learned under law of contracts as it is for e-commerce. Now, e-commerce refers to commercial transactions conducted electronically, especially on the internet. It includes buying and selling goods and services. Online banking, it also comes under e-commerce. It's a very wide subject. You put the question, what is e-commerce? When is e-commerce? Electronic banking, all financial transactions, and exchange of goods and services. Then allowing business and consumers to interact and conduct business without the need for the physical presence. All these matters comes under e-commerce. So it's a new concept. Sometimes you may exchange same goods or services, but considering the platform is electronic medium. So then you have to reshape legal provision relevant to these transactions and find out how to overcome these practical issues. This comes under e-commerce law or e-transactions law. In Sri Lanka, we call this law as e-transaction. The reason is our electronic transaction act is not confined only to electronic commerce. It's open to non-commercial activities. We'll discuss that if we have time. We'll discuss later.
So what is the governing law of e-transactions in Sri Lanka?
Now, prior to 2006, we didn't have any piece of legislation relevant to electronic transactions. Now, following United Nations Trade Commission, we call this UNCITRAL model law on electronic commerce in 1995. So they brought some amendment to this model law later in 1996 and 1997 and 1999. Then later, UNCITRAL model law on electronic signature First they introduce model set of laws to the world with an expectation to maintain uniformity of law relevant to all countries. The reason is, in cyberspace, there are no territorial jurisdiction. When you carry transactions using the internet, countries they have territorial jurisdiction. Country to country laws are different. Their socio-economic, political, and cultural reasons are different. But in cyberspace, you have to consider entire cyberspace as global village. No territorial jurisdiction. So if we consider this space as a global village, then there cannot be differences of laws applying to jurisdictions. To remove this, to eliminate these barriers, this United Nations Trade Commission came forward and introduced this model law. Based on this model law, Sri Lanka introduced Electronic Transactions Act in 2006. This is the basic piece of legislation, and it's a strong piece of legislation. Now, after application, what happened was, the rest of the world realized the model laws are not much powerful to carry these electronic transactions in the world. The reason is, model law, there is no mandatory, no compulsion to jurisdiction to apply these provisions. Then once again, United Nations came forward and they introduced UN Convention on International Electronic Contracts. Following this convention, because Sri Lanka became a signatory, we ratified this convention recently, and Sri Lanka, Singapore, and Japan, these are the three countries ratified UN Convention on International Electronic Contracts in the world. In Asia, from Asia. So you must be proud that we are pioneers in this field. Don't ask me about practical side, Nirodha, because we are pioneers as far as the ratification of this convention is concerned. So then we, after ratifying, we have international obligation since we ratified international convention. Then our lawmakers brought an amendment to this E-Transactions Act by Act number 25 of 2017. It enables principles for electronic signatures, electronic contracts, and authentications, promoting the validity of electronic transactions. These are the main objectives of our electronic transactions. There you can see the recognition of electronic offer and electronic acceptance. I hope that you are familiar to Section 18 of Prevention of Fraud Ordinance. To accept any agreement as an enforceable agreement under Section 18 of Prevention of Fraud Ordinance is, the particular instrument must be in writing. That's the first requirement. The second requirement is, there must be an authentication for that. Now, when we use the pens, pencils, and papers, we know that instrument is in writing. Then authentication, we know maybe a manual signature or maybe embossed seal or whatever. So this is these two, if you can fulfill these two requirements, then the particular agreement is enforceable agreement before law court. It doesn't mean that you can't build up any contract verbally or by conduct. No, you can. Take the example, Carlyle versus Smoke Ball case. By conduct, you can form a contract, but it applies to electronic world as well. But anyway, to bring those type of contracts to the enforceable level, then you have to prove that there was a contract, verbal contract or contract by conduct. But here, if the particular agreement is in writing and authentication is there, then you can you can prima facie, you can satisfy the court that it's an enforceable agreement. Now the issue is, under the development of ICT industry, now as I explained you earlier, now medium has been changed now. Now, if it is electronic medium, now how to satisfy these two requirements under Section 18 of Prevention of Fraud Ordinance? For that, we can see Section 4, 5, and 6 of Electronic Transactions Act come forward to fulfill the first requirement. The particular instrument is in writing. So you can't just say that electronic instrument is in written form. To fulfill that task, provisions are there under Section 4, 5, and 6. The reason is, some acts says to use particular instrument, it must be in its original form. If it is the requirement in a particular act, now how to use the particular electronic instrument to fulfill that task? Take example, like the permit under Land Development Ordinance, that you must produce the original permit. If it is in electronic form, then how to fulfill that requirement? So then we must have that additional condition for it. So this is what Section 5 says. We'll take another example. To carry a gun on streets, you must have gun license. So that license must be in your possession. Otherwise, you can't just carry a gun. There are people, they carry guns even without license, because it is not, these are the people I'm not talking about here. But normally, that is a law. Or without having a revenue license, you can't put a vehicle to the road. But today, you are in a position to get your revenue license online. Online. When the police constable stop your vehicle, you can show your mobile screen and say, this is my revenue license. Then they are given special code. With that, they can find out the genuineness of your document. Because that is how we brought this electronic instrument to the level of normal written document. So these are the provisions we can find under Section 4, 5, and 6 of E-Transactions Act. Next, come to authentication. Now, when you say this is electronic or digital signature, the placing of this signature is different to placing normal, ordinary manual signature. When you take digital signature, it is mathematical formula. Algorithms involved in that. So this is new to our legal system. To establish this electronic authentication, then we must have new legal provision for that. So this is what Section 7 of Electronic Transaction Act has done. The provision, the clear provisions are there under Section 21. What is electronic authentication? And how the court consider this electronic authentication as prima facie authentication. If any party wants to challenge, that is up to the person who challenged to disprove it, not to prove, disprove. So this is how we have developed the legal system, not only in Sri Lanka, that is how other countries also have developed their legal system to eliminate these barriers. So barriers as far as prevention of fraud ordinance is concerned. So this is the main idea. In addition to that, we can see, Nirodha, electronic communication. I hope that all are familiar to postal rule. This is what we learned when you are learning law contracts. Postal rule, receipt rule. Postal rule says the moment you post a letter, law presumes that other party received it. When you take the email and SMS, can you apply postal rule as it is? Considering the mechanism of sending email or SMS or MMS or email. It's a packet switching mechanism. Our message won't travel as one pack. The moment you release your message from your device, it will be divided into a number of message packets. So it will go here and there in the world, in cyberspace. Sometimes some packets will go to Alaska, Brazil, and come back to Sri Lanka. Another set of packets will go to Japan, Korea, and come back. So under these circumstances, can you just apply postal rule or receipt rule for communication? So then we must have that's a different mechanism. This is what Section 12, 13, 14 of Electronic Transaction. So here, what we have done, we have just hired articles introduced under UNCITRAL model laws initially, and they later introduced under UN Convention on International Electronic Contracts to our Electronic Transactions Act. So with that, we can carry out our electronic transactions and we can enter into international trade and commerce because we are also applying similar laws applied by various other jurisdictions. So this is the situation as far as electronic transactions in Sri Lanka is concerned, Nirodha.
Thank you, sir. Where we carry electronic transactions, consumer protection and data protection in cyberspace are core issues to address. Sir, what are the IP rights and personal data protection in cyberspace?
Now, when we were learning, first of all, we must understand what is intellectual property rights. Intellectual property is not tangible or intangible. We honor the intellectual creation or invention of a person. This is a special type of right. Now, under intellectual property law, basically copyright, patent right, trademark right, design right, and unfair trade practices. In United Kingdom, we can see business know-how and business secret. But in Sri Lanka, we don't have separate right for it. We can see it also comes under unfair trade practices. So these are the main basic rights guaranteed under intellectual property law. Earlier, we considered copyright for sometimes novels, books, music, drama scripts. But then computer software came to the world. So when you look at writing software, this is also intellectual creation. It's a skill of a software writer, computer engineer. So the entire world got together and decided to give the same status as far as copyright is concerned, to give the same status to software as well. Through case law, initially, this particular protection was built up. Later, World Intellectual Property Organizations, TRIPS, and various other conventions, and they all got together and decided to give copyright for computer programs or software. So we know to get copyright, one has to establish the originality of their work. Originality means not novelty, originality. And the author, only the author will get copyright. Even when we write a novel or book or whatever it is, the author will get the copyright. Likewise, the software writer, the computer engineer who involved in that software writing will get copyright if it is original. Now, Nirodha, it is very difficult to find out totally new software in the world. When you take software, it's a development of another software. But anyway, the second software has the originality for that person who created that software. That originality is there for that. So that second person can claim copyright for his good work because it is original to the world, but he has sometimes upgraded earlier version. Then how to draw the line? So then if there's a dispute, otherwise the original person might say, because the second person copied his work, then it is a test before courts. Whether the second person applied his skill, labor, and judgment to create that second software. So if it is his own judgment, if it is with a skill, based on skill that they are created, and he who invested money, if you can satisfy, yes, you will get that. Then once again, there are a series of judgments in the world. You can find out, you go to Google, then you will come to know about the latest judgments there. Starting from Franklin case, series of judgments are there. Then if a person copy another copyright work, then how to measure? If it is a book, Nirodha, that you can count number of pages and paragraph, then you will come to, yes, these are the areas the second person has copied. But here, person has copied software. You can't get a tape and measure. This is the length of software you copied. No, this is impossible. Then we call IPCOS computers case. Then in that case, judges give a test to find out whether a person has copied another's copyright work or not. Mainly, the claimant must establish that he who created the particular program, and originality is there. And substantive, if the person say that is his copyright work and other party has copied, then that person must prove substantive portion has been copied. Substantive portion means these are test before courts. Once again, you can't count pages and see, yes, this is a substantive portion. Sometimes after copying 99%, sometimes it is not a violation of copyright. The reason is the main part is in the other balance part, 1%. On the other hand, if the person copied that important 1% of the software, it is enough to establish that the person has violated his copyright. Then come to patent rights. Patent rights, you must establish that it's a totally new. That means novelty must be there. And the person claimant must establish inventive step and an industrial application. It's common to computer program as well. Now take the example, Microsoft, from those days we used Windows. The Windows various versions were there. The subsequent versions were not fit to get separate patent right for it, because there was no novelty involved in that. It's an aberration, but these aberrations is fit to get copyright. But later Apple mechanism came. Yes, that is totally new. That is totally new. Then Apple got a patent right for their good work. So likewise, you can get patent right for computer program, but you must establish novelty, inventive step, and industrial application. The next area is trademark. The trademark rights also there, guaranteed under intellectual property, and it's applied to computer programs and websites as well. But in addition to that, we can see today, as far as the internet is concerned, websites are concerned, domain name rights. Domain name rights. Now, take example, now we have BASL.lk. That's a domain. If I want to mislead another person, I can easily get BASL.com. BASL.com. Then, if I use that purposely with an intention to mislead the people who use BASL.lk, then one can say it's a violation of the domain name right. And sometimes it's a violation under Section 160 of Intellectual Property Act. So you can say it's a unfair trade practice. Then the special right was given, because it's also guaranteed under our Intellectual Property Act in 2003, based on WIPO Convention and TRIPS Agreement. Semiconductor chips design has given that special right. We call this as topography. Semiconductor chip rights. In United States, it comes under separate act. Lawmakers again, Semiconductor Chip Act. But in Sri Lanka, it's part of Intellectual Property Act. So this is how the lawmakers have guaranteed intellectual property rights as far as ICT industry is concerned. It's developing, but it will be very complicated, Nirodha, as far as the development of artificial intelligence is concerned, because we have to address this issue separately. Even there are lots of gray areas are there, unanswerable questions are there as far as the development of AI technology is concerned.
The intellectual property rights is a special right guaranteed to honor intellectual creation and invention mainly. So what is the involvement of intellectual property rights relevant to information and communication technologies?
Yes, as I explained you earlier, the intellectual property rights, we call IP rights, safeguard creators' rights over their inventions and creations. It's the basic companies providing them with exclusive control over their use in the digital environment. Because the person who has a copyright, he has economic rights and moral rights. Economic rights and moral rights. It's also guaranteed under our law as well. So then that person who can claim copyright can enjoy these two rights. So this is the guarantee, the rights under the copyright.
The cloud computing has reached human lives, and latest development is AI, artificial intelligence. What is the legal impact of this development, sir?
Now, first of all, you must understand what is cloud. I hope that, Nirodha, you are using now smartphones. All are using smartphones. So they feel that all these apps, so-called apps means applications, or software inside our device. No, most of our programs are not in our device. It is in a cloud. Where is your cloud? This is another issue. It is very difficult to find out what's the exact geographical location of our own cloud. The reason is the service providers who provide you that service, they don't disclose the geographical location of your own cloud for security purpose. Even now, even without our knowledge, now we are using this cloud. So everyone who uses this smartphone, especially if you use iPhone or iPad, you have the cloud. It may be private cloud or public cloud or hybrid cloud. Now, when you use this cloud, there are two issues arise. One comes under intellectual property law. Other one comes under data protection. Now, the rise of cloud computing and especially artificial intelligence has significant legal implications. These are the inclusions, data ownership. Now, take example, after preparing a document using your smartphone or device, now you want to save that file. Now you will go to file icon, you will click and then save. You will give a command. Happily, you can say, yes, I save this document inside my device. But it is not the mechanism. After clicking your file icon and after say save, give the name, it will go to cloud. It will go to cloud, not inside your device. So where is that the geographical location of your document? You don't know. The moment you click that particular icon, now it will go beyond your control. It will go to cloud. Where is that cloud? No one knows. It's maybe in Canada, maybe in Japan, maybe in New Zealand. We don't know. Because once again, we will come to the same point. In cyberspace, there are no territorial jurisdictions. Towers are there everywhere. Another mechanism is when you save a document using this cloud computing, the service provider won't save that particular document in a particular cloud. First, they will divide your document into a number of parts. If it's a document, they say, take example, divide into 4 or 5 parts. So that the service provider will send one part to, say, Argentina. Another Argentina towers. Another part will go to Moscow tower. Another part will go to South African tower. Another part will go to South Korean tower. One part will remain in Sri Lanka. The next day, if you want to retrieve this document, then once again you will go to file icon and click and open. The moment you give the command, file command, give the name of the file, automatically all these parts will come to your computer through this cloud computing mechanism. The time period, consider the time period, sometimes it will take 1 millisecond to happen this because the service provider will collect all these parts and deliver to your computer. Because this is how they maintain security. If there's a hacker attack there to your document, only the hacker can attack only part of this document. There's no point in attacking such a document. Now the issue arises, if you send a particular document, it's a very secret document, it's your personal data, then if it is beyond your control, then who is going to take the responsibility of your personal data in cloud computing? You may feel that's dangerous. It is a dangerous situation. If in cyberspace, we can't see this information. We can't touch. Now, after introducing this cloud computing, now it's beyond our control. I can remember when we started to use computers in early 1990s, we didn't have this problem. Because we purchased desktop, we saved at least 14 to 16 or 17 softwares, programs, and we happily use it. So after using, we saved our files also inside our device, computer. But anyway, the day by day, it became very slow. So after 1.5 years to 2 years, we changed the computer. This is what we did. But today, you don't need to change your iPad or iPhone or your device. This is the reason, because we are using cloud computing. Your softwares are not inside your device. Your end results is also not inside your device. Everything is cloud. So that is why you maintain the same speed, same capacity, almost same capacity when you use your device. Then a question arises about the data ownership. Who is the owner of data? You may feel that, no, I am the owner, but it's beyond your control. Then who is the owner of your data? The issues regarding who owns data stored in the cloud. Then there must be a responsible person. Then who the liability? If something happened to this personal data, who is going to take the responsibility? The determining liability for breaches or failures associated, especially with AI technologies. Now, if the service provider is there, yes, we can see there's a contract with the service provider. If it is AI, it's beyond human control. AI tools, AI device act as a human brain. No commands. If you can give command and control, that is not AI. So this also you must keep in mind. Artificial intelligence means it's beyond the human's intervention context, like our neuron cells inside our brain. These computer programs also behaving. Otherwise, it's a big data. It's a big data. Otherwise, big data. So once again, we have to draw the line between big data and AI. So if it is AI-based communication, then this problem will burst. Who is going to take the responsibility for our own personal data? If the data collector collect data applying artificial intelligence. Even the collector also can't give answer because it's beyond his control. So these are sometimes you may feel that lots of advantages are there. These are some unanswerable disadvantages as far as the development of technology is concerned.
Thank you, sir. So what are the disputes and dispute resolution mechanism available in cyberspace?
Now, we discussed about electronic communication, electronic transactions, even some data protection. When you discuss data protection, it's sort of the different subject. Briefly, I explained you the situation of the data protection as far as the development of ICT sector concerned. Then intellectual property rights inside the space. Now, whatever the fields or subject we discuss, there may be some disputes. Disputes of that, especially maybe a violation of some consumer protection regulations, or sometimes violation of electronic contracts, or breach of personal data protection. There may be a violation of some penal provisions introduced under Computer Crime Act or Online Safety Act. So then there are disputes are there, maybe under criminal justice mechanism or under civil law. So first we'll take under criminal justice mechanism. So what is computer crime? Computer crime means if any person carry misuse activities declared by the lawmakers of a particular country saying that it's involved in computers and network and it's a computer-based offense, we call this offense as cybercrime or computer crime or IT crime or whatever it is. Then as far as once again nature and behavior of electronic information is concerned, sometimes this system has created new criminal offenses. Now we are aware that series of offenses are there where we can find offenses under the penal code, under various statutes, for maybe the forest ordinance or bribery act or whatever. We can find the penal provisions there. But when you look at behavior, sometimes say hacking. Hacking means if a person obtain unauthorized access to a computer system, simply we identify this as obtaining unauthorized access. The layman's word is computer hacking. But we have learned criminal trespass on the other hand under penal code. What is the criminal trespass? If a person entered into another's occupation without getting permission or knowledge of the person, the occupier, then that he will commit that offense of trespass. But you can find some similarities. But no, this offense is not same. The reason is to commit the offense of criminal trespass, one must physically enter into another occupation of the property. But here, to enter into a computer, you don't need to enter into that computer physically. From the distant place, you can send virus program. Virus means this is a computer program. You can send a program to computer and attack that computer. So it's new to this criminal justice system. Applying the existing traditional offences, you can't deal with such a situation. So considering this new situation, initially, in United Kingdom, they introduced basically 3 offences: hacking, cracking, and computer modification under section 1, 2, 3, under Computer Misuse Act 1990. Following this Computer Misuse Act, in Sri Lanka, we introduced Part 1, Part 2, and Part 3 of Computer Crime Act in 2007. Part 1 explains 10 offences. 10 offences are there. So it doesn't mean that one can commit only these 10 offences, misusing computers or network. No. If you ask that question, how many offences one can commit relevant to computers and network, I can't answer. It may be millions or trillions. We don't know. But as far as the offences are concerned, there are some similarities with existing legal provisions under the penal code or other statutes. So then we can apply the same offences to deal with computer-based offences. But like the computer hacking and cracking, these are new offences to the criminal justice system. So very correctly, that lawmakers identify these 10 unique offences and put them under Part 1 of our Computer Crime Act in Sri Lanka. In United Kingdom, they have only 3 offences. But we have 10 offences. And when you come to Cybercrime Act in Australia, then the more than that. The reason is, once again, any country, the lawmakers introduce laws that particular country considering their socio-economic, political, and cultural reasons. So these reasons are different country to country, different. So that is why we can see that there are no uniform set of offences introduced in the world as far as computers and network concerned. Now, once again, when you take dispute resolution mainly, especially under criminal justice mechanism, earlier law enforcement bodies carried their investigations within their jurisdiction. Now the question arises, considering the once again nature and behavior of this electronic information, can we limit your investigation to a particular jurisdiction? Can you carry investigation successfully? I hope that you can easily understand. It is impossible. It is impossible. So then we have to expand international cooperation. Sometimes our law enforcement bodies must get the assistance of law enforcement bodies of another country. For that, we must have separate agreements or conventions. So this is what European countries initially got together and introduced Budapest Convention. We call this Cybercrime Convention. Once again, Singapore and Sri Lanka, we are signatories of the Budapest Convention. From Asia, we are the pioneers in that field as well. Then what happened was, then internet became very popular in the world. So then there are lots of offences taken place in cyberspace. So considering that, the entire world realized this Budapest Convention is not enough. So that is why last year, soon after Law Asia Conference in Hanoi, internationally, 52 countries got together in Hanoi. Then they introduced the first time international, the UN, United Nations Cybercrime Convention. Sri Lanka also signed that convention, but we are not yet ratified fully. All these countries are considering. So thereafter, we can find some uniform set of laws as far as cybercrimes concerned. And there may be enforcement mechanism may be there. Sometimes the courts mechanism also will be changed in future as far as these international issues are concerned. Then one unique thing we can find out, for the first time in any international contract, they have given interpretation for the electronic evidence. This is very important. So when we give different interpretation for electronic evidence by various jurisdictions, it is very difficult to deal with this issue. So this is the situation as far as criminal justice mechanism is concerned. On the other hand, that civil system is concerned. Now, when there's a contract, if there's a breach of contract, normally we will go before court litigation. Once again, the Electronic Transactions Act and your Electronic Commerce Acts are different from country to country. There will be an issue when the two parties from different jurisdiction, if they sign a contract, then what is the applicable law? if the judgment issued by one country, can you enforce that judgment in another country? Unless there's an agreement, you can't do it. So likewise, there are some practical problems. In the day by day, we can see the development of the electronic contracts, and business world expand more and more to the rest of the world. This is what we can see. This is what I explained you earlier. So then what is the mechanism? So one time all countries found a very good mechanism. That the mechanism means that is arbitration. Arbitration means it is not totally new mechanism to this world. Once again, during Vasco da Gama's time and Ferdinand Magellan's time, they used the same mechanism. But they were not just sailors, they were merchants. So they had common law to carry their trade and commerce. We call this as lex mercatoria. So lex mercatoria is the law of merchants. So then the jurist found this mechanism and reshaped, and now we call this as new lex mercatoria. The new legal mechanism system for merchants. It is not codified. It's not codified. The practice, through practice and case law, you can build up. And what is the mechanism? Mechanism they found is arbitration. So based on UN convention, so they found a fine mechanism. So Sri Lanka also that the signatory to UN convention. Based on that, we introduced Arbitration Act number 11 of 1995. When you look at UK Arbitration Act, you can find lots of similarities. So then now, after some time, people realize arbitration also not the real answer. Now the popular mechanism is now negotiation and mediation, commercial mediation. When you take commercial mediation, negotiation, now the new concept is online mediation and online negotiation and online arbitration. So these are new concepts developed as far as the development of ICT sector is concerned. Now, one hand, Nirodha, technology is developing. Another area we can see, we are improving our trade and commerce, professional qualities. On the other hand, we can see we are improving dispute resolution mechanisms. Now, I will answer the first question. It is mandatory to learn digital law. I hope that all get the answer. Without learning this subject, can you survive in future? So that is why this high time, this must be a mandatory subject to law college curriculum, law faculty curriculum. This high time, this is what other countries have done. We are far behind of most of the countries. At the moment, we have programs in the master's level and MPhil and PhD, but it's a high time to introduce this subject for first degree level or professional qualification level.
Thank you, sir. Are there any questions for the participants? No one has posted anything to the chat box. If you have any questions, you can post it. Until they post any questions, sir, if I could ask a question from you. Sir, what are the legal risks of sharing copyrighted content online, sir?
So once again, now, if the person can say that the person can say, yes, the so-and-so violated my copyright. Now, if the person, the wrongdoer can say, look, I didn't get this from your source. I got from another source. If it is in public domain, then it is very difficult to prove that the person has violated that copyright of the claimant. Because you can't limit this to the piece of music or the drama script now. If it is so, easily, if it is a public domain means even the poor judges also in trouble. How to find out this public domain and see, yes, this is but the second person will easily say it's a public domain. And he will bring some content material also from public domain. Because there are some people, they duplicate things and they produce a similar software, programs, various items. This has become a habit now. So These are the practical difficulties.
So can a person be sued for defamation on social media?
Yes. Now, there's an issue here, Nirodha. What we did was in 2002, we removed defamation part from our penal code. At that time, we didn't have this threat due to political promise of the then government, to satisfy some media personnel. What the then government, what they did was they removed this part, this chapter, entire chapter from the penal code. But later that the social media platforms developed in Sri Lanka. Now one can ask question, if you are using the same internet, if you are using the same websites, why some countries can easily control the social media issues, but why can't we do it? This is one reason. Criminal defamation is not an offense under our criminal justice mechanism at the moment. You can't reproduce this all. Then there will be a big issue then. Someone face a violation of our fundamental rights, there are no freedom of speech. But those countries, they didn't remove that defamation part from their criminal justice mechanism. They very successfully, they control the mechanism. So now we have the mechanism. This is only, that's under civil law. You can file civil case. In the meantime, when you look at third chapter of Online Safety Act of Act number 9 of 2024, then you can find the criminal defamation has been reintroduced under this act. That is why there was an issue against the bringing of this act. But there is some people say there can be a violation of our human rights. So once again, the government is also rethinking whether to activate this act completely or not, because of this voice raised by various sectors of the country. So at the moment, you have civil remedy, but to get this criminal remedy, of course, you have to wait some time. Otherwise, you can file private plaint under Online Safety Act. Because at the moment, there is no Online Safety Act Commission. Until such time, you can file a private case, private plaint under Section 136 of Code of Criminal Procedure Act before courts, magistrate court.
Thank you, sir. So what now? You have explained what is hacking. So is it always illegal, or can there be legal hacking also?
Once again, this country, we apply intention and knowledge as a mental element. This is mandatory. It is not apply for penal code offences. It applies to all offences. One good example is Tasaki versus Jayasekara's case. Even under Food Act, to establish any offence under criminal justice mechanism, the prosecution must establish intention or knowledge, criminal intention or knowledge of a person. Otherwise, it is not a criminal offence. So, likewise, it is applied to computer-based offences as well in Sri Lanka to fix a person under one of these offences. Then mental element is important. It is up the duty of the prosecution to establish and prove mental element, intention, knowledge beyond reasonable doubt. So this is the basic. It applies to all offences. Now, as you are, there may be ethical hacking. Ethical hacking means, now take example, when you purchase software, what is the expectation from the software house? Now, you will physically say that it is in a CD or pen drive, but you will purchase it and you will enter that to your computer. But to install that program, sometimes you need particular files, particular capacity. Then how do this computer software house people know about the capacity and the availability of the required files in the computer? Then you have to get a phone call and contact the software house. It will take them months to install one computer program. It is impossible. Even someone asks, do you have this particular files? I am not a computer engineer. I am not in that technology theory. So then I am not in a position to answer. Even if they asked, do you have this facility? I can't answer. So then we must allow the software house people to connect with your computer. So that's why I think you have already got this experience. When you install program, halfway the message come to our screen asking us to join internet. Connect your device to the internet. This is the reason. Connect the internet means the software house will get access to your computer. So then with the moment you connect your device to internet, So that means you will waive off your rights. So that means you will allow software house people to enter into your computer, not voluntary, non-fit injuria. This is voluntarily you are allowing them to come into computer. Anyway, so there are some limitations. Earlier that we didn't have this practice. Now you, I think, once again, that experience. When you install some program, when you use some websites, they ask, do you agree with our cookie policies? Cookie policies means they are the earlier we call these cookies as spy service. Now that is how sending cookies only they get this information. So if you don't like cookie policies, then you have to say, I don't like. So sometimes if you don't agree with their cookie policy totally, then you can install the software. That is end of your mission. So then it is up to you. Then it's a contract between software house and you. So then after giving this chance to software house, if they get this access to your computer, it is not unauthorized access. It is authorized access. So it is not an offense. So these are the new developments under this system.
Thank you, sir. So as a last question, as there are no any other questions from the audience, so should the government or any regulatory authority should regulate social media? If that is so, why and why not, sir?
Now, first of all, what is democracy? Democracy means you can't interpret democracy as anyone can do anything. No, that is not democracy. You must balance the situation. While you are safeguarding individual rights, you must protect the society. That is the answer. While you are safeguarding individual rights, you must safeguard the society. Now, what is our fundamental? Now, we have a set of fundamental rights. But fundamental rights are not pure fundamental rights under our constitution even. It is subject to some conditions. Subject to, take freedom of speech. To get this freedom of speech as shield, can you carry some harmful activities on others? Can you carry harmful activities in society? You can't. These are limitations. Even under constitution, those limitations are there. So we have to apply same theory here, even for social media. Social media is a good platform to exchange your views for the freedom of speech. Even this is not the right we get nowadays through these computers net. During all ancient kings' time also, this mechanism was there. Because they couldn't reach the king, ruler, because of their ministers and other assistants of the king. Ordinary people couldn't reach the king. Then what they did was, why this king was going somewhere, because they climbed to a tree and they expressed their grievance. So likewise, this is a good platform. But anyway, we must know what are our limitations. So controlling means if any person violate the law of the country, then that is up to the legal authorities to take stern actions again. Now, here the problem is, we don't know that how far our law enforcement mechanism is competent to detect the people who upload or download certain matter, whether they have proper interaction with international law enforcement mechanism. So these are the issues we have to develop. It is not a controlling mechanism. No. Already laws are there. Our criminal justice mechanism is also very strong. Unfortunately, that criminal defamation part is not there. Purposely we removed it. The British rulers introduced that. We removed it. But anyway, it's time somehow either to introduce and enforce this Online Safety Act or reshaping that enforcement, your Online Safety Act, or bringing a new act. So that very soon, without delay, you have to do it. One thing. So then we can see we have the attitude of development of the legal system. This is also, I think, we have opened floodgates for wrongdoers. So one example, now, when you reshape Desavalama law, Muslim law, Canadian law, then of course there's a debate still going on. For last 50 years, debate going on. Can you bring amendments at the same speed for digital law? Now, today we are talking about AI. How do you know that next month scientists that they will find some BI or CI or DI or we don't know, new technology. So then what happened to AI? Same thing happened to data protection. Now take example. Now we followed 7 principles under General Data Protection Regulations in European Union. And we hired these 7 principles to our Personal Data Protection Act number 9 of 2022. So now still that we are struggling to settle this law. But we couldn't implement this law fully. But then the people who introduced these 7 principles under GDPR, they have gone long journey. In European Union, they introduced AI Act, Artificial Intelligence Act. So then they tried they coupled AI provisions with data protection. So once again, they realized after introducing this AI Act, they lost some international investors because due to these rigid rules. Now they are going for some liberalization of AI now. So where we stand? We are still struggling to settle the 7 principles under GDPR here. At this speed, Nirodha, that we can't think about the successful that legal mechanism to deal with ICT sector successfully. So we have to expedite. This is not only the fault of lawmakers. Lawmakers also part. Law enforcement mechanism. Then lawmakers. And the third category, lawyers and judges. So we also must take responsibility for it. Without any delay, lawyers must learn this subject and apply these new laws. So then only that we can think about a successful legal mechanism. The one matter, Nirodha, I want to know, admissibility of electronic evidence is also very important as far as the development of ICT sector is concerned. Because under our evidence ordinance, initially we had verbal evidence, oral evidence, written evidence, and law of things. Well, this is a new member. Who's the new member? Electronic evidence. Now, how to apply best evidence rule and rule against CSA for this electronic material? Can we apply these 2 theories as it is for electronic material? So then our lawmakers also realize it is impossible, like other countries. Then they introduced Evidence Special Provisions Act, number 14 of 1995, and Section 21 to Electronic Transactions Act. So then presumptions, the admissibility of electronic evidence, basically based on presumptions. Otherwise, it is impossible to bring electronic evidence to the system. So based on that only, we can bring the video evidence, electronic or digital evidence successfully to the system.
Thank you, sir. As there are no any other questions posed by the participants, I will hand over the session to Kitmali. Over to you, Kitmali.
Thank you, madam. Thank you, ladies and gentlemen. This brings us to the conclusion of episode 31 of series 6 of the Basics of Law webinar series. On behalf of the Bar Association of Sri Lanka, I extend my sincere gratitude to our esteemed panelist, Dr. Sunil Abeyaratne Attorney-at-Law. Thank you, sir, for the insightful and enriching discourse and for generously sharing your expertise with us today. I also wish to thank our moderator, Ms.Nirodha Kalansooriya, Attorney-at-Law, for expert steering today's session. Thank you, madam. I further thank the Webinars and Legal Symposium Committee of the BASL for their dedication and hard work in organizing this informative webinar. And I extend my appreciation to all participants who joined us this evening. Thank you all for your presence and engagement. I wish you all a very pleasant evening.
Okay, thank you very much. Good night. Udah tak